Hello and welcome to the 48th episode of Business Litigation TV, the internet's most passionate show about business litigation. I'm your host, Jesse David Eisenberg, and I am a New York City business litigation attorney. Today's topic, I'm going to talk about an LLC. Now, especially in New York City, there are a lot of small mom and pop businesses. And most of those businesses, or at least a fair portion, are formed as a limited liability company, LLC. Now, LLCs, they're pretty easy to get started. They don't even require that you have what's called an operating agreement. And most people just do a standard operating agreement when they have one, and this poses a problem. Why does this pose a problem? Because an LLC standard operating agreement does not adequately describe what to do when one member is being treated badly or one member needs to be ousted. In fact, the general rule in New York is that a member of an LLC cannot be ousted. And, well, I'll get to this in a bit, but I was going to talk about what to do, how to dissolve a corporation, but we'll get there. So, first, let's talk about what to do if there's a member who is not cooperative or just unhappy and wants out in certain ways. I find there's about 4 standard things that can be done. Number 1, depending on the level of the business, how well it's working, the dissatisfied member can just walk away. That's option 1. Another option is that all of the members of the LLC say, hey, this isn't working, let's move on, and they dissolve the LLC. The next option, one of the members or a few members decide to buy out the dissatisfied or non-cooperative member. And then the 4th option is an outside person wants into the business and they buy out the non-cooperative or the dissatisfied member. So that's the easy ways. That doesn't require any courts. Probably still requires a lawyer if you're buying them out. But it's a much easier option and it's a lot cleaner. Now, what happens when a member, when none of those 4 options are available? What do? Well, a member can decide to start a dissolution action, saying I want to dissolve the corporation, courts should do it, here's why. Problems with that is if the corporation's making money and it's doing its stated purpose, like let's say an LLC is purchasing, its job is to purchase real estate and they're still purchasing real estate. They haven't decided to start buying gummy bears or something. Then the courts are not going to dissolve the corporation. Now, hold on just a sec while right, okay, well, as I said before, you can't oust a bad member, a non-cooperative, or a dissatisfied member. You can't do it. So, what do? You can't go to court to oust someone. You can't dissolve the business if the business is running well. What are you left with? All right, so what you're left with is two kind of similar options. One, you bring a case for what's called a breach of fiduciary duty. Because what usually happens in a case where someone's dissatisfied, they're not getting paid. And they've been moved to the side. They're being ignored, right? So you bring a breach of fiduciary duty. Whoever is managing the LLC has a fiduciary duty to the other members to make sure they are receiving their profits. Option 1. Option 2, you bring a derivative suit. If they're mismanaging the funds, the dissatisfied member can bring a derivative suit on behalf of the LLC saying you're mismanaging the funds and I'm taking you to court. So that's kind of a rundown on what happens, as I like to call it, when an LLC needs a divorce. All right, so there's options for you when you can find an exit strategy with the other members, and there are a few but not great options in New York when you need to go to court. Okay? If you have any questions, something I can address in your specific circumstance, please feel free to email me, jesse@jdelaw.nyc. All right, guys, as always, I appreciate you watching, and until next time, take care.